Welcome to the Supreme Court of the United Kingdom, where today we are hearing an appeal in a case called BF Eritrea and the Secretary of State for the Home Department. The respondent, who has been given the designation BF, has been anonymized in order to protect members of his family in his home country. I'm hearing this appeal with four colleagues whom I'll introduce now. Lord Lloyd Jones.
Good morning.
Lord Briggs.
Good morning.
Lord Sales.
Good morning.
And Lord Burnett. The appeal is concerned with the Home Office's policy relating to the initial assessment of the age of asylum seekers who claim to be children, that's to say, under the age of 18. And the main issue the court's being asked to decide is whether the policy is lawful. The Secretary of State is represented by Mr. James Strawn, Queen's Counsel, and I'll hand over now to Mr. Strawn and invite him to begin his submissions.
Thank you, my Lord. This appeal raises two issues of general public importance. The first relates to the correct test for the courts to apply to a challenge which seeks to attack the lawfulness of policy or guidance produced by a public body as to the exercise of its functions or those of its officials. And the second connected question specifically relates to the lawfulness of the Secretary of State's policy here for immigration officers in the important task of filtering out claims of those when first encountered claims to be a child, but where they do not have supporting documentation and where the claim seems obviously wrong or false. My Lord, I should have introduced those appearing against me, but Mr. Permer and Mr. Butler appear for BF and Ms. Christie for the intervener. Assessing someone's age is accurately without documentary evidence is a difficult task at any time, and the Secretary of State's immigration officers are routinely confronted with this task when dealing with migrants entering the country without such documentation. And the Secretary of State's policy overall, we submit, ensures that all applicants are given the benefit of the doubt in these circumstances. Where there is doubt, they will be treated as a child, pending more detailed assessment. But this is not about those cases where there's doubt. It's about filtering out those cases where immigration officers are sure at that initial stage that the person is not a child. And there are obvious and important legal differences that apply in consequence of whether someone is a child, i.e. under 18, or an adult. Recognition of someone as a child brings with it a host of protective measures for the safety and welfare of children, particularly in the immigration context, including, of course, limiting both the time or circumstances in which one could be detained for immigration purposes. Those protections include the Secretary of State's long-held policy not to detain children for immigration purposes, except in very limited circumstances, which are now given statutory force by the amendments to the Immigration Act of 1971 by the 2014 Act. The many other protections include things such as access to child services. Giving the applicants the benefit of doubt at the initial stage serves to safeguard and promote the welfare of children, even when there is doubt as to the veracity of that claim. But it is also important for the protection of children and the integrity of the immigration system from abuse, not to treat those who are obviously adults as if they were children. And inevitably, the host of legal protections that come with the status of a child also inevitably give rise to an incentive for some to claim to be a child when they are in fact adults. And there is an incentive to do so in order to evade immigration control that would otherwise apply to adults and to gain the protections that would apply to a child. Immigration officers are often faced with such false claims at the outset when someone may have entered illegally with no supporting documentation. The policy seeks to deal with that situation, ensuring that even those cases where the claims are considered dubious, the applicants get that benefit of doubt, pending a more detailed attempt at verification of their age. But in those cases where there is no doubt in the immigration officer's mind, subject to the procedural safeguards that the policy itself contains, then the claim will not be accepted, and immigration officers can filter out those claims. My lords, everyone to date in these proceedings has accepted that it would be unrealistic and inappropriate for immigration officers merely to accept all claims by any person to be a child without more. Such a system would be unworkable, and any migrant without documentation could otherwise obtain such status and the known advantage that comes with it on their mere say-so, regardless of how dubious the claim was. And likewise, everyone to date in these proceedings has accepted that an immigration officer cannot, on such an initial encounter, immediately carry out what's become known as a full Merton compliance assessment, based on the description of the B and Merton case, to which I'll come to shortly. It's simply not possible to conduct such a detailed assessment at that initial stage. And my lords, if I just give for your notes, for references, the upper tribunal judge's conclusion to that effect at paragraph 49, E248 of the electronic bundle, and Lord Justice Underhill's judgment in the Court of Appeal at paragraph 53, E191, 53 to 54, paragraphs 53 to 54. It's also recognised that immigration officers will inevitably be considering the issue based upon physical appearance and demeanour of an applicant at that stage. And again, that's recognised both by the upper tribunal below and the Court of Appeal. The upper tribunal was paragraphs 35 to 36, electronic bundle 240, and the Court of Appeal at paragraph 56, electronic bundle 192. And they rightly rejected the contention that physical appearance and demeanour was an inherently flawed criterion. It's also important to note that in light of this court's decision in A and Croydon, ultimately the true age of a person can only be definitively determined by an adjudication by a court. Age may be an objective fact, but it's not legally knowable absent such a determination. None of that obviates the need to filter out what are obvious cases without the benefit of such judicial determination. But there is always the potential that any assessment, if not a judicial determination, and that includes those carried out with a Merton compliance assessment, may ultimately be incorrect. In that respect, we say the respondent does not really address the issue we've identified in our written case at paragraph 22, electronic bundle 67, that this potential also applies to the use of Merton compliance assessments. And that exposes the basic problem of seeking to question the lawfulness of this policy on the basis of the assessment of some sort of underlying risk, however it is put, that the assessment may ultimately prove to be wrong. We submit that's not the proper legal approach for testing the lawfulness of the policy. But to address the problems confronted by immigration officers, the Secretary of State's produced detailed, we say highly precautionary, and careful guidance to immigration officials to assist them in their task at that initial stage. There are a series of safeguards, and I'll take you to them, aimed at avoiding treating a child as an adult, including consequently avoiding the detention of children, and advice is provided as to the requirement to avoid that consequence. But the policy also addresses the ability to filter out obvious cases, and we say an entirely legitimate way. The policy that we're concerned with is principally articulated in the assessing age asylum instruction and also section 55.9.3 of the enforcement instructions and guidance, which I'll come to very shortly. The policy applies a clear and strong presumption that a person who claims to be a child will normally be treated as such, even if their claim is doubted. There are only limited circumstances when that presumption is overcome, and the policy strongly builds into it the benefit of the doubt principle. And in that respect, the term age disputed cases is actually a description of those cases where the doubt exists and the person is treated as a child rather than adult for the time being, pending resolution of that dispute. It's not covering those cases where the doubt doesn't exist. Each of the limited circumstances under the policy where a claim to be a child will not be accepted at the initial stage only apply having given the applicant the benefit of that doubt. And there are four which are set out in the policy documents. The first is where there's clear and credible documentary evidence that someone is aged 18 or over. The second is where the individual has already been subject to a more detailed Merton compliant age assessment, concluding that they're 18 or over. The third, with which you're specifically concerned on this appeal, is where the physical appearance or demeanour very strongly suggests that they are significantly over 18 and no other credible evidence exists to the contrary, and that's assessed independently by two officers to be the case. And the last is where the individual initially claimed to be an adult, but then changed their claim after being detained. And there's no documentary evidence or other evidence, and their appearance very strongly suggests that they are age 18 years or over. So the criteria are limited in scope, reflecting the wide application of the benefit of the doubt. That third criteria, criterion C, as it's been referred to in the EIG document, has to be read alongside with the accompanying policy for the officers, which also applies before they reach such a conclusion. It advises them on applying the benefit of doubt and the importance of reaching a careful decision. In the guidance of the form that was before the Court of Appeal, the limitations on using physical and appearance and demeanour are explained. The need to be sure someone falls into that category before applying it is identified. And what's more, it's not the judgment of one person. There is a need for a separate, independent assessment by a higher-ranking immigration officer, the second pair of eyes, as it's colloquially called, to reach the same conclusion. And we say in considering the legitimacy of a criterion of that kind, it's important not to misread the case law in this area. The Merton case itself, which I'll come to in a bit more detail in a moment, is clear that detailed age assessments are not required in every case, but only borderline cases. And as identified in that case, in some obvious cases, there isn't the need for prolonged inquiry, as it's put. And it's explained, or was thought in that case, the difficulty normally only would arise where the person concerned was approaching 18 or is only a few years over 18. And that was what was envisaged by borderline cases, where, and in other cases, a full age assessment was not contemplated. Criterion C, in its wording, is intended to operate in those non-borderline cases, where the immigration officials consider the physical appearance and demeanour very strongly suggests that the person is significantly over 18, so displacing that benefit of doubt. And even in those cases, of course, the applicant can in due course challenge that assessment if they see fit to do so. My lords, the fact that any such system is not completely risk-free in outcome in our submission, doesn't make the system inherently unlawful. Indeed, if that were the applicable test, then the ability to rely on Merton compliant assessment under criterion B would also be in question, because Merton compliant assessments aren't risk-free in that sense either. But to be clear, my lords, we don't accept the assertion made in the respondent's written case at paragraph 3, subparagraph 4, that there is an uncontested proposition that a significant number, whatever that may mean, of children, which can only be referring to those established to be children, have a physical appearance or demeanour which may very strongly suggest they're significantly over the age of 18. The evidence doesn't establish that, and it's disputed as a proposition in principle by us. In the event, the majority of the Court of Appeal found criterion C to be unlawful, not in principle, but on a much more narrow basis, namely that the word significantly used in the policy required some further gloss and needed to include reference to a specific age to reflect the margin of error, although the Court of Appeal did not identify any specific age itself. It's clear from the intervener's submissions, paragraph 48.3 of their written case, that they consider the margin of error to be 5 years. The respondent is not so explicit. The written case of the interveners at electronic bundle 155, that paragraph. We submit that the Court of Appeal's approach proceeded on an unprincipled basis. The use of the word significantly has to be taken with criterion C as a whole and the accompanying guidance and the benefit of doubt that it expresses. And it certainly doesn't reflect any error of law in the Gillick sense, as I'll come to in a moment. We submit the Court of Appeal proceeded in error in testing the lawfulness of the policy against a different test of whether there still remained a risk of more than a minimal number of children being detained, or whether such risk could be reduced by the Court of Appeal's concept of a better formulation. We say that even if tested against those tests, or indeed another test such as inherent unfairness, the Court of Appeal was wrong to treat the policy as unlawful anyway when it's read properly as a whole. We submit the upper tribunal was right to reject the challenge to the lawfulness of the policy as it stood at that time, in light of the benefit of the doubt it reflects, the safeguards it embodies, and your lordships will have the upper tribunal's judgment, section D, E227, electronic bundle page 227. That was based on an earlier version of the combined policy. Of course, by the time the Court of Appeal reviewed the matter, the policy had been updated to provide an even more precautionary approach, which in the minority judgment of Lord Justice Simon satisfied him that it wasn't unlawful. It's not entirely clear to us, and ultimately, what use the majority made of statistics, the disputed statistics, but we submit they were wrong to place any reliance upon them, given the upper tribunal's observations about their limitations. And of course, by the time the Court of Appeal was looking at the updated policy, those statistics couldn't have had any evidential force at all, because they related to the policy application in its earlier form, rather than the updated form before then the Court of Appeal. And so it's for those reasons we submit the Court of Appeal erred in each of the three ways we set out in our three grounds. But what I propose to do before coming to those specifically is just address the Court briefly on the legal framework, the policy framework, and the facts before dealing with the grounds of appeal, and then finally the intervener's additional submissions. My lords, as to the legal framework, follows. Yes, my lord.
Just before you do, Mr. John, you said that it was the intervener's case that the margin of error was 5 years. Is there any dispute about that? Because your own guidance mentions a 5-year margin of error, doesn't it, at page 752, for example?
My lord, sorry, my lord, your camera froze, but I think I caught the end of your question.
The end of my
whether there was a
point.
dispute. Yes.
Yes, I just wonder whether there's any real dispute about the 5-year margin of error, because I thought I had read in your own guidance, for example, at page 752, a reference to the same margin of error and it having and its source. I'm just looking at the page now.
My lord, the source of reference to, I hope this answers your lordship's question, the source of reference to a 5-year margin of error is in fact a reference to guidelines from the Royal College of Paediatricians from 1999, yes, and is in fact a reference to a margin of error of up to 5 years for paediatrician assessments, which are obviously not the same as assessments by an immigration officer on physical appearance and demeanour. The paediatrician assessments were those which were produced by, in some cases, paediatrician reports, which are seeking to be medical assessments of physical characteristics of an individual. And that's where that margin of error is expressed in those guidelines, which in my submission doesn't equate to the margin of error which is said to apply to, for example, initial stage assessment by immigration officers who are considering physical appearance and demeanour as part of an interview of an applicant. So there is a potential distinction, and some care needs to be taken as to where that margin of error reference occurs. And so that I'd simply draw that to your lordship's attention. Yes. I hope that answers answers your lordship's point. I'm going to come to the, if I may, in a moment, just come to the Merton case, because the paediatrician, the Royal College guidance that your lordship's referring to is referred to in that case. It's set out in the text of the judgment.
Yeah, thank you.
My lords, the legal framework, of course, the overall framework is that of the functioning of the immigration system. And there's obviously a wide range of legislative provisions and case law, but as a result of which, the distinction as to whether someone is a child or an adult has a number of different consequences, both under the legislation and, of course, the immigration rules. The specific focus, of course, of this claim has been on the potential susceptibility to detention. But it's important to remember that determination of whether someone is an adult or child doesn't of itself necessarily mean they will be detained. The determination that someone is an adult rather than a child as an initial stage doesn't automatically result in detention at all. It's wrong to assume that as a corollary. And my lords, before I turn to the specific the two pieces of legislation that the courts have focused on below, could I just deal with the B. and Merton case itself? That's in the electronic reference 2040, under Authorities 1, tab 7. And that was a decision of Mr. Justice Stanley Burton, who then was in 2003. And I'm sure the members of the court will be very familiar in principle with the concept. But it arose in the case of a dispute over the age of an asylum seeker who was claimed to be 17, and respective responsibility for him, depending upon whether that claim was true. And the authority had determined that he was at least 18. But at paragraph 4 of the judgment, which one can see on electronic page 2041, both parties sought assistance as to the requirements of what a lawful assessment was in that context, or what was required of one, and that led the court to set out some guidance. The problems of age assessment in the absence of reliable documentary evidence are discussed at paragraph 20, or the recognition of that. And in answer to my Lord Briggs' question, I hope, or indirect answer, at paragraph 22, you'll see the guidelines of the Royal College of Paediatrics and Child Health, to get the title correct, set out there. And that is where the 5-year margin of error for paediatrician assessments is expressed. My Lords, at paragraph 27, just asked the court to note the points I was making in my opening remarks, that the court itself was recognizing the principle that there may be cases where it's very obvious that a person is under or over 18, and the absence of a need for prolonged inquiry in those cases. Indeed, the difficulty you'll see at the last sentence normally only arises in cases such as the present, where the person concerned is approaching 18 or is only a few years over 18. But the possibility of such cases, of obvious cases, means it's not possible to prescribe the level or manner of inquiry so as sensibly to cover all cases. And at paragraph 28, you'll see that the court there had in mind an age range, say, of 16 to 20, as to be when that might require the sort of age assessment that was being contemplated. Paragraph 35 referred to what was then the Home Office policy with the predecessor to what is criterion C. And at that stage, the policy involved an assessment based on appearance alone. If you see at paragraph 8.1 of the court's judgment, and it appears the term significantly over 18 didn't apply in that policy at that stage. And at paragraph 36, it's in that context that the court said the assessment of age in borderline cases is a difficult matter. The term borderline is reflected in the Home Office policy. You'll see it at paragraph 35, the quoted paragraph 8.1, borderline cases being those which someone wasn't considered by their appearance, strongly suggesting to be over 18. And it's paragraph 37 of the judgment was distinguishing between clear cases, accepting clear cases. One shouldn't determine age solely on the basis of the appearance of the applicant. And that, of course, then led to the guidance that the court gave as to what would normally be required of what then became known as Merton compliant assessment. And again, at paragraph 38 of the judge's judgment, at the end of that paragraph, it's repeated, in an obvious case, the appearance of the applicant alone will require him to be accepted or as a child, or conversely justify his being determined to be an adult in the absence of compelling evidence to the contrary. And also, there is a paragraph 50 as a statement which may not have stood the test of time as to the approach of age assessment in this context. Judicialization of what are relatively straightforward decisions is to be avoided. And as I've stated in such cases, the subject matter of decision is not complex, although in marginal cases, the decision may be a difficult one. And it will depend on the level of inquiry, depending on the obviousness of the case. My lords will be very familiar, of course, with the way in which the subsequent jurisprudence has built upon the Merton case. And there has been considerable development as to what then is required of a Merton compliance assessment in terms of, for example, the presence of 2 social workers, interpreters. Those have come out as subsequent requirements. And my Lord Burnett, in his judgment in RZS Afghanistan, in the Bundle of Authorities, tab 18, E2327, has an analysis of the way in which the Merton principles have indeed evolved over time, with greater requirements as to what's said to be necessary for a Merton compliant assessment having been built in. But leave that aside, the basic principles expressed in Merton as to when one would need to conduct such an assessment in my submission have not changed, nor consequently has the legitimacy of an approach of making assessments at an initial stage in the way immigration officers do in non-borderline cases, that has not changed. The second point to note about the legal context is that of A. and Croydon itself, the Supreme Court's decision, your own decision, which is in the electronic page reference 2199.
Just before we leave, Mr. Ford, just before we leave Mr. Justice Burnton's judgment, he makes a very important point in paragraph 1, that back on page 041, that the Nationality, Immigration and Asylum Act doesn't apply to those who are not aged at least 18, with the consequence that whether you are 18 or not determines whether you fall within the scope of the entire system dealing with asylum seekers on the one hand, or of the responsibility of the local authority under the Children Act of 1989 on the other. Now, so if, just say, for example, the aim of the policy was to identify whether people were significantly over 18, then it could very well be argued that that was an unlawful policy because it was failing to reflect Parliament's evident intention that anybody who is 18 is to be dealt with under the Nationality, Immigration and Asylum Act rather than under the Children Act. And so while the policy may be expressed in terms of being significantly over 18, its objective, I think, in order to be lawful, must be to identify people who are actually 18 or over. Because if you're if it's your 18th birthday, you fall under one statutory scheme rather than another.
My Lord, yes, that's certainly indeed. And what we have identified in this context, which may be linked to that point, is the importance of not treating someone who is actually an adult as a child. And that's clearly expressed in paragraph 1, but it has other consequences beyond what's said in paragraph 1, although they probably flow from the similar statutory schemes. If one is treated as a child, then of course one is placed into or accesses child services, potentially placed with children in that context. And that in itself raises its own issues as to the protection and promotion of welfare of children.
Yeah.
So
I was making was that evidently there are all sorts of practical implications which are important, but simply in terms of legality, Parliament has made it abundantly clear that the line is to be drawn at the age of 18. And a policy that fails to reflect that is not going to be a lawful policy.
My Lord, yes, although for the purpose of the way the policy, which I'll show your Lordship in a moment, works, the way in which it works where there's doubt as to someone's age is, of course, to treat them in the interim as a child, but to follow up the process necessary to try and establish the true age. And so there is a degree of, if I can call it, pragmatism in that respect, that in order to find out, and for legal purposes, whether the person is a child or an adult, then there will be a further, more detailed assessment process. But in the meantime, sorry,
are you going to explain to us what the legal purpose of the initial assessment is?
But my Lord, yes, but of yes, indeed. But the legal purpose, I mean, in short, is in order to make a decision as to whether someone is immediately treated as an adult or a child, with all of the consequences that flow, not just those in paragraph 1, but of course, at the initial stage of assessment, when one encounters an immigration officer, as in this case, there may be, as a consequence, immediate detention of someone, depending on whether they are an age, an adult or a child. That was obviously more common as a concept when one was dealing with potential take-back requests for someone who traveled through another country under the Dublin III principles, would be returned back to that country if they had previously claimed asylum, and they might therefore be detained at the initial stage. But there are a number of purposes of determining whether someone is an adult or a child at the initial encounter, and the policy sets the framework for doing that, giving the benefit of the doubt, as I've indicated, in any case where there is doubt. But where there isn't, as is required in order to fit someone into the legal framework, making a decision as to whether they are to be treated as an adult or child. That, I mean, that in a sense, that is what the policy purpose is to enable immigration officers to understand whether they should be treating them as an adult or a child for all of the consequential provisions that then bite. And Lord, I'll come to that, if I may, in the context of the policy itself.
Very well.
The A and Croydon decision that I was going to just mention for your Lordship, again, you'll be very familiar with that. But that similarly raised a link point to my Lord Reid's point a moment ago, that in that case there was a issue, and that's at 2199 of the electronic bundle. The importance of age determination was there, in that case, important in order to understand whether someone was a child in need for the purposes of the Children Act. This is section 20. Because the definition of whether someone was a child or not was one of the prerequisites to whether you were a child in need. And the Supreme Court obviously has decided that the definition as used in section 20 of a child in need is a definition which requires the term a child to be construed as an objective fact, ultimately decided by the court in the event of dispute, not a matter of judgment by the relevant local authority. And that means, of course, that for the purposes of that legislation, the question of whether someone is or is not a child in the event of dispute ultimately is resolvable only by a court determination in the event of continued dispute. And that, in my submission, is an important context for the policy that is before your lordships. Of course, we recognise that whether someone is or is not a child is ultimately only knowable definitively through such a process or agreement in the absence of definitive evidence. And that will always be the case. And in that sense, there is always the potential for a subsequent court decision to overrule, for example, even a Merton compliant assessment that has made a judgment one way or another. And the court is, of course, the final arbiter. And in that sense, there may be if this is the right language, a risk of a different outcome from a court decision as compared with an earlier decision made on any other type of assessment. But that is part of the overall context of that legal situation. Can I then, with that in mind, just turn to the legislative context here, because there are two pieces of legislation which the courts below looked at and which remain relevant. The first is Section 55 of the Borders, Citizenship and Immigration Act 2009. It's in the bundle at E1934. But Section 55 is the duty placed on the Secretary of State to make arrangements for ensuring that immigration and asylum functions are discharged, having regard to the need to safeguard and promote the welfare of children who are in the United Kingdom. And that duty under Section 55 was considered in the immigration context by this court in the case of AA Afghanistan at electronic reference 2241, tab 14 of bundle 1 of authorities. And it was contended in that case that Section 55 of the 2009 Act meant that detention of someone in the mistaken but reasonable belief that they were an adult, when in fact they were a child, was unlawful because of Section 55. And the court will see that from that case, the dispute had arisen in circumstances where there was an age assessment from social workers concluding that the individual was an adult. Paragraph 4 of Lord Toulson's judgment records that scenario. Paragraph 10 identifies that some 2 years later, or nearly 2 years later, a subsequent Merton compliance assessment concluded that the individual was in fact a child, and that came to be accepted. So exposing, of course, how things can change with competing Merton age compliance assessments as they come along. The court considered in that case the policy, many of the policy provisions that are currently in issue before the court today, and you can see from Lord Toulson's judgment at paragraph 16 through to paragraph 25, so beginning on page 2246, an analysis of Section 55, and then, of course, the age assessment policy and EIG provisions that are in very similar form to those before the court today. So take at paragraph 19, letter E, you'll see those 4 criteria. And it's in that context that the court both decided that there wasn't any breach of Section 55 or any unlawful detention in that context where someone acted on the mistaken but reasonable belief someone was an adult who was subsequently accepted to be a child. And Lord Toulson also made some observations which we accept aren't, of course, not binding on this court in any event, but were obiter in respect of commentary on the policy. But at paragraph 47 through to 49, there are, we say, persuasive observations about the way in which the balance or the promotion of the Section 55 duty involves some degree of competing assessments. And you'll see at paragraph 48 the commentary about the instructions in assessing age, those are the ones which we're concerned, are detailed and careful, and they comply with the Section 55 obligation. And at paragraph 49, letter D, it was always recognised that these assessment processes, be they Merton compliance assessment processes, or as indeed we would say criterion C, the risk of an erroneous assessment can never be entirely eliminated. It can be minimised by a careful process, and there are appropriate safeguards. In addition to the process for making initial assessment, which includes requiring the benefit of any doubt to be given to the claimant, the Secretary of State is under a continuing obligation consider any fresh evidence, and then its age assessment can be challenged on judicial review, which would be bound to be respected. We submit that those principles or those observations about compliance with the duties under Section 55 in the context of that sort of policy remain pertinent today. If I turn then to what's changed in the legislative context since those
Mr.
observations.
Strawn,
Yes.
Mr. Strawn, before you move on, I wonder if I could just ask you, the guidance with which we're concerned, is it made pursuant to Section 55, subsection 3?
My Lord, it certainly, I believe it's actually not made pursuant to that, but made pursuant to common law powers, and indeed it predates in various forms Section 55 3 itself.
Thank you.
A point that's striking me, Mr. Strawn, is that while, for understandable reasons, cases like AA Afghanistan have focused on the risk of treating people unlawfully if they're mistakenly treated as adults when they're actually children. There is the problem the Secretary of State has is that it would also be unlawful to treat people as children if they are actually adults. You know, if, for example, you fail to deal with them as asylum seekers when they ought to be dealt with under that regime. And if you look at it, if you're thinking about it in Gillick terms, there's a very fine line, really, between the problem is, if a policy, in Gillick terms, if a policy encourages or sanctions the treatment of people in a way which would be unlawful, then you have to be careful, on the one hand, not to encourage the treatment of people who are actually over 18 as if they were under 18, and also not to encourage the treatment of people who are actually under 18 as if they were over 18. I mean, all the focus in this case and perhaps in AA Afghanistan is on one side of the problem. But there is, when you think about it, there's actually an equivalent problem if you err in the opposite direction.
My Lord, yeah, your Lordship's absolutely right. There is a corresponding side of the coin, if that's the right way of putting it, to deciding whether someone is an adult or a child. My Lord, I accept that. Of course, the focus or the sole challenge here relates to the one direction of treating someone as an adult, whether they should be a child, rather than whether the policy struck the right, or indeed in Gillick terms, correctly advised as to the problems of the other way round. And so that's what I'm here to meet. But my Lord, I understand the point. When we look at the policy, in my submission, it adopts a lawful approach to that issue, but there is an important principle that emerges from what your Lordship's identified, that certainly where criterion C is concerned, which is seeking to deal with obvious cases, it would be wrong in principle to treat obvious cases, at least where the immigration officers apply those tests, as if they were children. But my Lord, I'll show that in the policy itself, but I understand the point. All I wanted just to point out is what's changed, of course, since AA Afghanistan. There has been a legislative change. Whilst it's always been the Secretary of State's policy not to detain children for immigration purposes, except in very limited circumstances, the Immigration Act of 1971 has been amended by the Immigration Act of 2014. And so that paragraph 16.2 of Schedule 2, and you'll find these provisions in electronic bundle pages 1924 to 5 and 1930. But the short point is that for, save in limited circumstances, it's unlawful to detain a child for immigration purposes. And that is, of course, a legislative change. It's one which the respondents seek to rely upon, but in my submission, it's not one which actually affects the lawfulness of the policy at all. It's always been the case, as a matter of policy in any event, not to detain children. And the creation of, or I'm just pausing there for a moment, the High Court and the Court of Appeal considered that legislative change and its effect in the case of AA Sudan, and the Court of Appeal's judgment in that case is at E2442, Electronic Bundle 2442. I don't think I need to take the court to it, but the short point that emerges from that case is that the definition of a child in those provisions is similarly treated as a matter of objective fact, as it was in A and Croydon, so that a form of strict liability arises, retrospective strict liability, if it subsequently turns out one has detained someone who you reasonably believed to be an adult, but in fact is subsequently determined to be a child. It will have been unlawful detention because of those provisions. And that was really what the Court of Appeal decided in that case. But the mere creation, I say mere, but the creation of that form of strict liability through that legislative change was rightly rejected by both the upper tribunal below, paragraphs 45 to 53, and by the Court of Appeal at paragraphs 77 and 78. The electronic bundle references for both those are E246 and E198, but rightly rejected as a basis for impugning this policy. If anything, of course, the creation of retrospective strict liability just adds to the protections that someone will enjoy because they will have an ability to claim for unlawful detention if it subsequently is discovered they were in fact a child. But it doesn't affect in our submission, the approach or the need to make an initial assessment. So, can I just then flag up the policy itself? We have in our written case at paragraphs 40 to 59, bundle E73, identified where you can find the policy, but can I just make these brief observations about it? First of all, as in so many areas like this, it is policy which evolves. It is changed in order to take account of events. It, for example, takes account of updates as to what's required of a Merton compliant assessment as those evolve. It takes account of, as in this particular case, the changes to the Immigration Act itself in 2014 with the conclusions of the Court of Appeal that I just mentioned and the importance of that. So your lordships have faced, unfortunately in those circumstances, with versions of the policy that existed before the upper tribunal when it examined the position, and the version of the policy which existed before the Court of Appeal when it then re-examined both the upper tribunal's assessment, but also what was the policy at the time before the Court of Appeal. And that rather, in our submission, exposes the difficulties of challenges to policy which are divorced from specific fact, which is what this case is now has proceeded on. Because as the policy changes, one then has to consider, well, which is the policy that's particularly under challenge. It is comprised in the document Asylum Instruction Assessing Age. The version before the upper tribunal is at E736, and the version before the Court of Appeal, version 2, is at E766. And I just want to just flag up, if I may, in those documents, the key parts which we've extracted in our written case. But if I take the court to E738, you can see paragraph 1.1, the purpose is set out of the guidance. This is the version before the upper tribunal. And the E739, you'll see at page, top of the page, assessing age general policy. The context is explained as to where cases are doubtful, a more detailed assessment of the age is required. And 2.1 deals with initial age assessments. And paragraph 1 in this version has what is reflected as criterion C in the accompanying enforcement instructions guidance. And just you'll see that the assessing age policy deals with section 2.2, the section 55 duty, and adverts to the statutory guidance, Every Child Matters, and sets out principles relevant to that. And over the page, E741, the section 55 duty in the assessing age policy is dealt with. And the screening process is described on E742. In other words, just as a general principle, because a question was raised about margins of error and, for example, the pediatric guidelines, it's relevant to note that within this guidance, at E746, you'll see it also contains guidance about local authority age assessments, Merton compliant assessments. It advises immigration officers about those, how to consider them at the bottom of page 5.2, and some detailed guidance given about that. Section 6, page E750, deals with other evidence of age. And it's in that context that immigration officers are also advised at E752, paragraph 6.5, about paediatrician reports, which are sometimes provided. And it's the specific guidelines of the Royal College of Paediatricians is set out with that margin of error 5 years either side that we were speaking about a moment ago. That's at the middle of page E752. So even within the overall policy itself, immigration officers are being made aware of all of the elements of margins of errors that appear depending upon the type of evidence that's in issue. And of course, E756, weighing up conflicting evidence of age, it raises a specific problem, one which is pertinent to the facts of this case, that there's sometimes a number of Merton compliant assessments for a particular individual, which sometimes have conflicting conclusions on what to do in those circumstances. And finally, at section 11, E762, it deals with the possibility of immigration judge findings on age. Sometimes there may actually be a determination by an immigration judge to be taken into account. Well, that's the position as it stood at the time of the upper tribunal in relation to the assessing age policy. E766 is the updated version. By the time it reached the Court of Appeal, and there are a number of changes in what had occurred, but we've tried to summarize those in the written case. But it's important really just to note E774, there's a whole section on initial age assessment. And one of the updates is, of course, to deal with the change in legislation that had occurred to the Immigration Act. And it specifically advises immigration officers as to the creation of that form of strict liability if you get it wrong. And it also advises on E774 in the bullet points, the 5 bullet points, as to the importance of not making the wrong decision, and the impacts that you could have on a child if they were a child of treating them as an adult. You'll see there in the various bullet points. And that in light of those risks, you can see Home Office policy, therefore, is to apply the age assessment process in such a way as to guard against the detention of children generally, including accidental detention of someone who's believed to be an adult but subsequently found to be a child. And over the page, you can see how that's explained with the benefit of the doubt principle. And in answer, I hope to agree to my Lord Reed's question, what the policy is seeking to do is therefore balance the problems of requiring one to make an assessment to get it right, but at the same time to give the benefit of the doubt because of those competing tensions as whether someone is a child or an adult, the benefit of the doubt principle, if a claim is doubted, treat the person as a child initially, but follow up with a Merton age assessment, as you can see at E775. And in our submission, you also then need to look at, and I'm not going to obviously read through, but E776 through to E779, there is detailed guidance given to immigration officers about initial age assessment based on physical appearance and demeanour. And the problems with relying on appearance and demeanour are fully explained, the difficulties of doing so. You can see, for example, at the bottom of E77, ethnicity and genetic background can affect physical appearance, as of course can a migrant's experience in particular countries or indeed on the journey. And assessing demeanour in an immigration context, bearing in mind different ways in which people express their mannerisms, claims culture, whether they're exhausted at the time, are all set out in some detail over the pages 778 through to 779. And then you have the decision itself process at 779 under the heading of the decision. Although levels of maturity can be assessed, maturity is not an accurate reflection. And you can see these words, middle of the page. This policy is specifically designed to allow a large margin of error in favour of the claimant's claim to be a child. It achieves this by requiring Home Office staff only to treat them as an adult on the basis of their physical appearance and demeanour, where they conclude that these indicators very strongly suggest that they are significantly over 18. That takes account of the challenges in assessing a claimant's age in such circumstances. And of course, at the bottom, there's a requirement to serve a form IS97M, which tells them the results. E784 sets out detail on the process of safeguarding and welfare of children. And there's further parts of the guidance which follow the procedural requirements of notifying the claimant of a decision, E785. And the form they're notified with, of course, adverts or alerts them to the fact that they could seek a local authority assessment if they challenge the conclusion.
So really, Mr. Strawn, if I'm understanding this correctly, the critical aspect of the initial age assessment, or critical from the point of view of its legality, is that legality of the policy is that it's a purely interim assessment pending a decision on how an individual should be treated after fuller assessment.
Well, that's in any case where there's the immigration officer doubt the claim.
Yes.
Where, however, the one exception to that is if they doubt that they conclude that, I say one exception, there are four, but one of the four exceptions is criterion C, where it's a non-borderline case, and they can say, we, from the physical appearance and demeanour, it very strongly suggests they're significantly over 18.
Yes,
They're going to treat
yes.
you as a
But the
child.
point I'm getting at is that on the face of things,
Sorry.
that criterion would be unlawful because it's not directed to the question whether the person is over 18. That's not the test. It's whether they're significantly over 18. And the problem becomes worse when the policy is phrased in terms of whether the person appears to be 25 or over in the current version. Because the statutory test is 18, not significantly over 18 or 25 or over. And so the only basis on which I think one can defend the legality of significantly or 25 or over is that it's a purely interim decision pending a full assessment. And so the argument has to be that in the interim position, it's the Secretary of State is entitled to err on the side of have an inherent bias in the policy in favor of treating people, of giving people what you call the benefit of the doubt. In other words, treating people as children where there is room for doubt, because while an error either way results in unlawfulness, the practical consequences may be more serious for the person if they're erroneously treated as an adult than if they're erroneously treated as a child.
Well, that last point is recognised, but in terms of the legality of the policy, I put it in this way, that the way the policy works is that with criterion C, immigration officers are satisfied that this is an obvious case where someone is an adult and they're treated as such. And it's not an interim position. They will be treated as an adult unless that person goes and challenges that conclusion. For those people who may in fact be adults, but who are not caught by criterion C because there's doubt, then they are referred for further assessment in order to explore what the true legal position is, and then a judgment has to be made in due course. So
in the meantime, am I right in thinking they would be cared for under the Children Act rather than under immigration and asylum legislation?
My lord, yes.
Yeah. So they are, for the interim, treated as children.
Indeed. And that, yeah. So far as criterion C is concerned, it's certainly, in my submission, lawful because it's based on the position that those are people who are concluded to be adults and they're treated as such. So it's only the other category of person that your lordship's question is directed at, but those are subject to further assessment. Yes, it is the case that they'll be treated as children, but that's a balance of the competing considerations pending further assessment. I hope that answers your lordship's question.
Yes, I mean, you see, the point is that if the statute says treat them as children, unless they're over 18, and the policy says treat them as children unless you believe they're significantly over 18, that's not reflecting the statute, and so it has to be justified, and I think in terms of the purely interim stage at which that policy is being applied.
My lord, yes, but yes. Well, as I said, that is what the policy does. I showed you that passage where they'll be referred in those disputed cases, as I put it. They'll be referred for further assessment. My lord, I'm going to turn. Could I just before I break, because I know your lordships want to have a break a single moment, just to say that that's the age. Asylum instruction age assessing policy, and those should be read, of course, with the enforcement instructions guidance which accompany that, upon which particular focus has been made. The version before the upper tribunal begins at electronic bundle 532, and the criterion C part is at page 566. And the version before the Court of Appeal, the equivalent version, begins at 598 of the electronic bundle. And the relevant section is 636. There isn't actually a particular material difference between the two, save that the Court of Appeal version begins with an express requirement to read it with the assessing age asylum instruction. That other document I've just taken you to. But the criteria also identify those 4 criteria identified, I've explained. And so I wasn't going to take the court to them. Is that a convenient moment to have your short break, my lord? Or
Thank you very much. It would be, Mr. Strawn. We'll adjourn for 5 minutes.
thank you.
I think we're ready now to resume. Mr. Strawn.
Thank you very much. My lords, I am conscious of the time, so I just wanted to deal very briefly with the facts. I'm not, they're covered in our written case section and also in the statement of facts and issues. Can I just make these brief observations about them? The first is that criterion C was applied to the respondent. A challenge as to the legality of that application was dismissed. And so any challenge to the lawfulness of the application of criterion C in his particular case has gone. Secondly, as part of that, the immigration officers concluded that he was an adult in his mid-20s. So this was an assessment, even on the revised Court of Appeal concept of reference to age. It wouldn't have changed, we submit, materially the outcome. And the third observation is just to illustrate the problems that I've already indicated about age assessment. In this particular case, there were 2 age assessments conducted by local authorities, Newport City Council, and your lordships have those in the bundle, page electronic bundle 1351 was the one on the 6th of January 2015, conducted by 2 social workers with an advocate, an appropriate adult and an interpreter, which concluded he was over 18. A second age assessment on the 24th of February, followed up by the 12th of March 2015 by different social workers to the same effect, and that electronic bundle 1338 with the follow-up at 1360. And it was only after those were challenged and there was a consent order that a third assessment concluded that he was under 18, and that occurred in September 2015. And that assessment is at page 1367. And what that exposes in my submission is, of course, even those age assessment processes can lead to different results. And far from illustrating any defect in the policy which is directed at the initial assessment by officers, it exposes that even if one applies Merton compliant assessments, one can end up with conclusions that someone is an adult, but subsequent assessments concluding that person is in fact a child, which again, as I pointed out, illustrates the inappropriateness of testing the legality of policy by reference to the risk of incorrect outcomes, which appears to be the way in which the respondent's approaching it. I turn therefore to the grounds of appeal. The first ground, of course, is what we submit was the error of approach by the Court of Appeal in the test that it applied to challenge the lawfulness of this policy. And the Court of Appeal's approach, as we understood it, is at paragraph 63 of the judgment of Lord Justice Underhill at page 194. challenge or the assessment was on the basis that the policy would be unlawful if it created a real risk of more than a minimal number of children being detained. And then later in the same paragraph, he talks about the policy themselves creating a risk which could be avoided if they were better formulated. So we consider that potentially two tests being applied, but we deal with both. We submit that that is the wrong test, and one has to be careful to identify the correct test in any public law challenge. I'm very conscious that the same panel of this court's already heard another appeal raising issues of principle as to the correct test to apply in challenges to policy, and I'm going to try and avoid repeating submissions that have already been made by the same Secretary of State, albeit in a different context. But in short, we submit that one has to be careful to identify what is the correct public law challenge. It is, of course, possible for challenges to be brought to either legislation, delegated legislation, or indeed policy on the basis it's ultra vires, beyond the powers of the individual making the rule or making or issuing the policy. One such example of a conclusion to that effect is, of course, the Supreme Court's decision in the Unison case and the Lord Chancellor, where it turned out that the conclusion was that the relevant order was in fact beyond the powers of the Parent Act by restricting access to justice in the way it did, as well as infringing a constitutional right of access to the courts. And that one can see an ultra vires claim is a perfectly legitimate basis upon which to challenge either legislation or potentially even policy. But in our submission, there is no ultra vires challenge mounted to the policy in this case. It's not said to be beyond the Secretary of State's powers to issue, as a matter of common law, policy dealing with assisting how immigration officers should approach their task. Instead, we submit the correct test is that expressed in the Gillick decision of the House of Lords, where it's recognised that one can consider the lawfulness of policy if it manifests itself positively an error of law. It advises incorrectly what the state of the law is. And I know this panel has already looked at the speeches in the Gillick judgment. The decision here, sorry, the authority of Gillick is in the bundle and at electronic page 1944. And it probably won't be fruitful for me to go over it again after it's so fresh in the panel's mind in a lot of detail. But all I would simply emphasize in that case is it becomes very apparent from Lord Bridges' speech at 192A to 194B that the jurisdiction that the House of Lords exercised over the memorandum in question arose because of a straightforward or distilled question as to whether the law was correctly stated. And Lord Bridge makes it clear that where there is advice in policy which is erroneous in law, so the advice itself is erroneous in law, the court has a jurisdiction to intervene and correct that error of law. And the similar approach was adopted in the Royal College of Nursing case which preceded it. And in Gillick, of course, it was the memorandum which was an issue, and that required the court to identify, well, what is the advice that's being stated in the memorandum, and then to consider its lawfulness. Lord Scarman's speech, in my submission, is important in that respect, both because when one talks about whether guidance permits or authorizes or encourages unlawful conduct, it needs to be seen in the context of what Lord Scarman was identifying, namely permitting someone to do something because of a positive, erroneous statement of law. But Lord Scarman's speech is also particularly relevant to this particular case, in my submission, at 181C, because one of the things that Lord Scarman observed, having identified, first of all, what's the true meaning of the text over the preceding page, and then identifying the issue of law, he also considered the question of...
What page, please?
I'm so sorry, it's E2012 is the start of the relevant passage at E, and then the particular passage that I was drawing the court's attention to is at 2013 C to E. And there was an issue about the lack of clarity in the guidance or that memorandum as to the concept of clinical judgment. What that was adverting to was the possibility, of course, that a general practitioner or a doctor might, in fact, prescribe treatment without meeting the more restrictive requirements of whether it was in the interest or reflected clinical judgment, and that the absence of specific guidance on what constituted clinical guidance might then affect the lawfulness. But what Lord Scarman, in my submission, made clear is that the guidance would be within the law, as set out at letter C, will be within the law, notwithstanding its lack of precision, unless its vagueness creates so obscure a darkness that it could reasonably be understood as authorizing to prescribe without the parent's consent wherever one should think fit, wherever he should think fit. And so it didn't have that quality, letter E. If one just takes that for a moment and applies it to this context, of course, the Court of Appeal did not, when we're not purporting to apply Gillick in their analysis because they adopted a different test. But had they done so, the very exercise that they embarked upon as to considering the term significantly to lack sufficient precision because it leaves a degree of judgment to the immigration officers would fall foul, in our submission, with what's being expressed here in Gillick. True it is that the word significantly over 18, therefore, still leaves to the judgment of the immigration officers a degree of judgment as to what significantly over the age of 18 is. But that doesn't, in our submission, invalidate the lawfulness of the policy by having that degree of judgment retained within it, any more so than it did, for example, in the memorandum, where doctors would be required to apply clinical judgment. Nor indeed does the prospect that the guidance might result in an unlawful outcome if, for example, the doctors fail to apply clinical judgment correctly in a particular case. No more does it make this guidance unlawful if, in fact, immigration officers either fail to apply the term significantly correctly or indeed reach a judgment which ultimately may prove to have been incorrect for whatever reason. None of that affects, in our submission, the validity or lawfulness of the guidance as expressed against the Gillick principle. And the best test for that is to read the guidance again, or indeed ask the respondent, what is the erroneous statement of law contained in the policy of the Secretary of State? And the answer is there is none. To the contrary, what the guidance expressly identifies, or the policy, is the importance of getting the age assessment correct, the dangers of in fact treating someone as an adult when they are a child. All of that is entirely consistent as a correct statement of the law, and it then simply identifies that in an obvious case on an initial assessment, if someone very strongly suggested to be significantly over the age of 18, treat them as an adult, because that is a perfectly legitimate way to approach them. So in our submission, if one applies Gillick in the way we say it should apply, then there is no question of this guidance being unlawful. The subsequent decisions where Gillick has been applied in our submission support that. There is the decision in Letts and the Lord Chancellor, E2275. I won't take the court to it, but Mr. Justice Green, as he then was, comments about the application of the Gillick principle were all concerned with guidance which had forensic bite, and in that case wrongly advised, specifically wrongly advised, as to the scope of Article 2 of the Convention as to when it was engaged, and i.e. a clear manifest error of law on the face of the guidance, which would then consequently permit, in that sense, authorize or encourage, sanction a decision based on that erroneous view of the law. There is no such error in this policy at all. And so the court will note that the upper tribunal rejected the Gillick challenge for the reasons essentially that I've identified. See paragraph 59, Electronic Bundle 252. And of course, ironically, the Court of Appeal didn't apply the Gillick approach at all. So I can't point to whether they would have upheld it, but in my submission, if had they applied it, they should have come to the same conclusion. The respondent, in its written case, seeks to say, well, there is a manifest error of law on the face of the guidance, and your lordships can see that from their written case, principally at paragraph 70, page E130. And it's revealing in our submission that the respondent now seeks to articulate this as a Gillick type challenge, even though that's not what the Court of Appeal, how the Court of Appeal approached it. But in our submission, the submissions the respondent makes under paragraph 70 do not reflect the Gillick approach. What the respondents are there pointing to is to the different principle that whilst the guidance itself or the policy itself is not manifesting or stating any error of law, it may possibly lead to incorrect decisions when applied, because they say it's inevitable that if you apply this criterion, some people who may turn out subsequently to be children will have been treated as adults. But the answer to that is very short. As in the Gillick case, the fact that something, when a policy is applied, may result in incorrect decision doesn't make the policy unlawful. And certainly we do contest the proposition that it's established that there will inevitably be a significant number of such cases, which appears to be the contention. That's neither established by the evidence, and in fact, the statistical evidence is unreliable in that respect, but certainly it doesn't establish that. But that raises perhaps a more fundamental question about the use of potentially wrong outcomes as a test for the policy in the Gillick sense, and indeed later on in any other sense. The possibility of an unlawful outcome on the application of a policy which requires judgment is not, in our submission, a reason to hold that policy unlawful. And I come back to this simple proposition: if that were the test or were the case, then it wouldn't even be possible on that scenario to use Merton compliant assessments, either at initial stage or even later on, because it's known that Merton compliant assessments may subsequently be changed or overturned or result in a different decision, as in this very case. And so one would then be into the territory of questioning, indeed, the whole ability to rely upon anything other than a definitive judicial determination before one could ever reach an outcome as to how to treat someone. And that therefore reveals in our submission the absurdity of looking at the risk of outcome which may ultimately prove to be wrong as a way of testing the legality of the policy in the first place. Neither Gillick requires that, nor we say, as a matter of common sense, can that be the right approach. So if one takes each of the paragraph 70 of the respondent's case, there is no identified policy which is erroneously in law, which they say in paragraph 70, subparagraph 2, the guidance to which they refer says that immigration officers who treat those persons who very strongly suggest from their physical appearance and demeanour significantly over 18 requires an exercise of judgment by the immigration officers. It's not inevitable in that sense that it's bound to result in an incorrect outcome. To the contrary, it's generally directed at securing the correct outcome. The fact that there could be errors, it's not a risk-free system, doesn't affect the analysis. Now, Lords, so we say Gillick is the right approach. Applied properly, it cannot, for the same reasons the upper tribunal gave, result in any quashing of this policy. And indeed, it reveals that the Court of Appeal's approach of testing whether the policy could be better formulated to reduce the risk or matters of that kind goes beyond the authorised boundaries of a test which is looking at the legality of the policy rather than its detail. What of other tests that have been applied in this context? Well, in the upper tribunal and indeed the Court of Appeal, the policy was tested against the test of whether it's inherently unfair. And that is a test which has, as your lordships will be aware, been applied in a series of cases, principally relating to procedural fairness of a system. And there is a long line of cases starting with the Refugee Legal Centre Court of Appeal decision, which moves all the way through a whole series of challenges that look at new systems to assess their inherent fairness or otherwise. And in those long line of cases, such as Refugee Legal Centre, a challenge to a scheme for fast-track adjudication system of asylum applications, through to TABAC, the Court of Appeal decision in TABAC, Bundle 2256, where Lord Justice Richards was looking at the fairness of an approach to the imposition of licence conditions for MAPA prisoners, through to the detention action decision of the Court of Appeal in Electronic Bundle 2312, which considered fast-track rules for asylum appeals. And then the Court of Appeal's decision in RS Director of Legal Aid Casework, Electronic Bundle 2382, where there was a challenge to the exceptional case funding scheme under the 2012 Legal Aid Sentencing and Punishment of Offenders Act. All of those cases, I should say, there are others, Howard League and Penal Reform for Lord Chancellor, Electronic Bundle 2500, Woolcock 2530, and indeed a more recent decision from the Court of Appeal, which I know my Lord Burnett was a member of that court, looking at the removal window change of policy. All of those were looking at a system which was introduced by reference to a test of inherent unfairness. And in that latter case, also impeding access to justice, whether it was permitted. And a test of inherent unfairness is therefore well recognised in those decisions, which looks at whether what is introduced impedes or, in effect, creates inherent unfairness in the system, so interfering with basic principles of access to justice. The policy here was tested by the upper tribunal in that respect and found to be lawful. And when one thinks about it, it is obviously so. This is an initial age assessment where the immigration officers had nothing more than physical appearance and demeanour to rely upon. Everyone accepts there isn't the ability to do more at that initial stage. The benefit of the doubt is provided. There are two immigration officers who had to reach the same independent assessment based on appearance and demeanour, and they only do so in those obvious cases, treat someone as an adult, by reference to the test I've indicated, and the applicant in question is served with a letter which indicates that they can, of course, seek a local authority age assessment if they continue to dispute the outcome. And so there isn't any inherent unfairness of the type that's analysed in those cases, any of that line of cases, which can be attached to this policy. And indeed, it's difficult to see really that the respondent is pursuing with any vigour that sort of test. What then of any other test? Well, the Court of reference has been made to the Unison decision of the Supreme Court and the Northern Ireland Human Rights Commission case, and indeed some reference to Beebe. And certainly, so far as the intervener is concerned, a decision of the Supreme Court in Munjaz, in order to suggest a test of real risk or significant risk of a unlawful outcome. And in our submission, none of those authorities support that proposition that such a test applies to assess the lawfulness of policy of this type. The Unison decision, as I've already indicated, which the court's very familiar with, was looking at the issue of whether those particular introduction of fees was ultra vires, the Parent Act, and of course impeded the basic principle, constitutional right of access to justice in circumstances where specific authorization in legislation would be required in order to have such an effect, and that was found not to exist in the Parent Act. And where my Lord Lord Reeve refers to real risk of access to justice being impeded, it is in circumstances where the measure itself is known and its effect is known, because it was the imposition of fees which had a consequence. There's no element of judgment involved. It's the imposition of a measure which the court could then assess against the test of whether it impeded access to justice or indeed was ultra vires. It's a very different situation to a policy such as this, which is identifying an approach for immigration officers which still requires the application of judgment. Indeed, the significant need to assess someone and consider whether they're significantly over the age of 18. It's certainly not, in our submission, a basis for extrapolating the real risk reference that's made in Unison as setting up a new test by which one can test the lawfulness of policy, contrary to the Gillick approach. And it was never, in our submission, intended to act in that way. What then of the Northern Ireland Human Rights Commission, Beebe, and indeed the McLaughlin line authorities? Do they say anything different? In our submission, no. In those cases, the Supreme Court were considering were potential breaches of convention rights. In the Northern Ireland Human Rights Commission case, it was, of course, Articles 3 and 8. And they were doing so in the abstract, of course, with the dangers and difficulties of doing that in the absence of concrete facts. But in all of those cases, for example, Lord Mance, in his speech E2584, at paragraph 82, and in similar tests such as Beebe, which he cites, the question that arose was whether something was bound to lead to a breach, or inevitable is another way of putting it, in order to test in the abstract whether such a measure, or such as was in question, would breach a convention right. The difference that appears to have arisen in the case law that follows, for example, Baroness Hale's statement in Re McLaughlin at E2661 at paragraph 43, is whether one uses some sort of numerical difference between whether that's an inevitability in all or almost all cases, or in a legally significant number of cases. But in our submission, that issue of whether it's all or almost all, or indeed legally significant, is nothing to the point in this context, because what is required is that the measure in question must inevitably result in a breach of a relevant right in order for this test to apply at all. And the policy that we're concerned with under criterion C does not inevitably result in any such breach, be it of Article 5, unlawful or common law unlawful detention. To the contrary, if one asks the question that was asked in BB is, can it operate compatibly with either the common law or indeed Article 5, the answer is clearly yes. By applying criterion C, immigration officers can indeed identify those who may well indeed be adults, because that's what the evidence suggests. They are also required to apply the judgment of significantly over the age of 18, and if they do so in a precautionary way, again, there is nothing inevitable about any detention of someone who may prove to be a child. But it also comes back to the point I've sought to make earlier, that that sort of test has the basic problem of distinguishing or conflating the question of an outcome with the principle of the policy. Of course, as I've made clear in this context, there is no system which could be ever entirely risk-free for all the reasons I've previously explained, even if one may use Merton compliant assessments. If by risk-free, one means that one would always get it right, and that every subsequent judicial determination would reach the same result as at the initial stage, or indeed Merton compliant assessments. There is no such possibility of any system, but that does not render the general policy or the approach in the policy unlawful if, on the application of the facts, they may in fact prove to have been a wrong decision subsequently. So, for example, someone's able to bring an unlawful detention claim because a court subsequently concludes they were in fact a child when they were wrongly treated as an adult historically. The ability to bring a claim in the future on specific facts where the policy has been applied incorrectly, as it turns out, remains, but it doesn't invalidate the lawfulness of the policy in principle. And in that sense, there is a close alignment, we submit, between that sort of analysis and indeed with that in Gillick itself, where there's an obvious distinction between lawfulness of policy on its face as compared with the potential for incorrect decisions in the application of that policy on the facts. The court is at this stage concerned with the former, because it's looking at the type of what Lord Reid described ab ante challenge to a piece of, in this case, policy, it might be legislation, and seeking to determine or assess its lawfulness against any of those principles that I've identified. Does it express an error of law? No. Will it result inevitably in breaches? No. Could there be erroneous decisions? Yes, of course, but that's the same in any system of any kind. My lords, in those circumstances, I should just mention Munjaz. Your lordship probably heard about that. But of course, the basic difference with Munjaz is that the court was assessing the policy, a seclusion policy, against Article 3, which incorporates a positive obligation not to expose someone to a risk of Article 3 treatment. So the term risk that's used by the House of Supreme Court in that case, and indeed a subsequent case of Rabone, is actually testing the policy against the requirements, the specific requirements of Article 3. But it's wrong in principle to interpret that are then creating a general test that any policy has to be assessed against whether there's a risk of an unlawful outcome. In some senses, those submissions I've made are identifying tests which the Court of Appeal didn't apply, but they are the range of tests that the courts have applied in other cases. The Court of Appeal's test, of course, was in our submission, a composite of real risk and numbers, because it talks about a real risk of more than a minimal number of children being detained. And we say that that is not an applicable test in principle. It differs from Gillick, it differs from inherent unfairness, and it is not considering even the type of authority which is dealing with incompatibility with convention rights from an inevitability perspective. But even on the Court of Appeal's test, if one were to apply it, one immediately confronts significant difficulties. How is one to quantify what a real risk is in this context, bearing in mind that everyone accepts that one is able to carry out initial age assessments without Merton compliant full analysis, and indeed it's necessary to do so. Risk is obviously, in that sense, just an inevitability. What does a real risk of more than a minimal number of children being detained mean? What is a minimal number? And of course, the question of whether someone is a child ultimately is capable only of resolution by the court in the final analysis. This case exposes that difficulty. The Secretary of State has accepted that the respondent will be treated as a child for immigration purposes because of the existence now of a Merton compliant assessment, the third one, which results in a different view, but not that the individual is in fact a child for the purposes of the unlawful detention claim, which would of course need to be adjudicated upon by a court. And one can see immediately the problem that now arises in relation to statistical evidence in understanding what statistical evidence means. If someone is initially treated as significantly over the age of 18, but as in this case, subsequent Merton compliant assessments ultimately result in a view that they are indeed a child, there may still yet be the need for some formal resolution of that for the purposes of a definitive assessment of whether they are a child or not. And that, as A.M. Croydon establishes, would ultimately be a matter for the court. But even if one takes the Court of Appeal's test on its own terms, we submit that the Court of Appeal erred under ground 2 in concluding that there was a real risk of more than a minimal number of children being detained in this case, taking that test, because of course, looking at it in the round, the policy is in fact, because of its precautionary nature and all of the safeguards it embodies, actually reducing the risk so that it will be only a minimal number of children being detained, if at all. Difficult to quantify that, of course, but we submit that the policy, for the reasons I've explained, and in particular, as the policy stood when the Court of Appeal had it, reflects a very precautionary approach in dealing with appearance and demeanour and the problems with it. And with that, just leave, sorry, Lord Sales.
I just wanted to check what your position is on, if you like, the prior question. Was the Secretary of State obliged to have any policy at all in relation to the treatment of immigrants at the first stage, against the background of the statutory rules regarding treatments of children one way, treatment of adults the others?
My Lord, I think the strict answer to that is there's no obligation to have a policy. the law obviously requires judgments to be made and ultimately a decision to be made as to whether someone is a child or an adult, but there's no specific requirement for the approach to that exercise to be spelled out in policy, at least none that I can immediately think of.
So I was just thinking that if there were no policy, you say no obligation to have a policy, all the immigration officials would be left with is the statute that says if over 18 treat one way, if under 18 treat in another way, in various contexts. They'd still have to make the same judgment on the same evidence, where in cases where in principle all you've got is the evidence of appearance and demeanour, which is what criterion C is seeking to deal with.
My Lord, that's precisely the case. And in my submission, what the Gillick line of authority demonstrates is that merely by providing policy to try and assist in that task doesn't render it vulnerable to attack on the basis that it doesn't go down to the degree of precision which the court may think is desirable, which is what's occurred here. Because the Court of Appeal's criticism of the criterion C, as I've indicated, is very limited, because it's not in fact challenging the principle of a criterion, but rather challenging whether the word significantly does all the necessary work of alerting immigration officers to the margin of error that can occur in such cases. And that's a type of Gillick criticism. It could be made about, well, you should specify more as to what constitutes clinical judgment. It's exactly the same criticism. And in my submission, there isn't any legal basis for attacking the policy because it is considered not to do enough work. As it happens, we also submit the Court of Appeal went wrong because read as a whole, in fact, the margin of error, whatever that may be, the principle of the margin of error is set out in the policy. I referred you that, referring to the concept of a margin of error. In answer to my Lord Briggs' question, there isn't actually a known margin of error for physical and appearance demeanour judgments by immigration officers to which one could make specific reference. But insofar as there is a known margin of error for paediatrician assessments, immigration officers are told about that. So they get full information in order to be able to make a judgment as to whether someone's significantly over the age of 18. Lord Briggs.
Unless I've missed something, a reasonable immigration officer reading this policy as a whole and reading what he's told about the margin of error for paediatricians would not be likely to think that he could do better than a paediatrician, would he, if all he's got is appearance and demeanour to go on?
My Lord, I suspect your Lordship's right in practice that the margin of error would be treated by immigration officers as highly relevant to that question. All I've alerted the court to is that there is a distinction between what a paediatrician does and an immigration officer, because one of the factors that's clear in the policy is that by interviewing someone, taking to a degree some account of what they're stating and what they say, you get more than, say, a medical examination, which is really looking simply at physical characteristics, albeit as a medical examiner. So the paediatrician is not actually taking account of that element of demeanour, if that's the right wording, because there's a degree of interview. But my Lord, there is a recognised in the guidance that margin of error for paediatricians, and immigration officers are told about it. And so it can't be.
I mean, the reason I put the question to you is that might well impact back on what the immigration officer would read into significantly over 18.
My Lord, yes, it would. There would certainly affect. In my submission, it's perfectly legitimate for them to take that into account in reaching their judgment. But what they of course applying a composite test of physical appearance, demeanour, very strongly suggesting that they're significantly, which is somewhat different to what a paediatrician might be doing.
No, I raise it only because of the Court of Appeal's view that significantly didn't do the necessary donkey work?
Well, my lord, in my submission, it does, and
Yes.
it allows that judgment to be made with the benefit of all the information that goes as to the precautionary approach. But once you start, as the Court of Appeal seeks to do, impose a specific age by reference to an unknown specific margin of error, one is into territory of specifying something which adds, in our submission, nothing greater, perhaps potentially more prescriptive than a judgment about significantly, which is perfectly lawful in this context.
Mm.
My lords, I'm conscious of the time. So far as ground 3 is concerned, it's a challenge to the use of the statistical evidence. You've seen that in our written case. Lord Justice Underhill said he would have reached his decision, paragraph 69, E196, without reliance on it, but he took it into account. Lord Justice Baker relied upon it at 102. Lord Justice Simon didn't. We submit it's inherently unreliable for the reasons the upper tribunal gave in its judgment, paragraphs 64 and 65. It doesn't provide an overall picture. You need to know what the overall picture is. Of course, the respondent's evidence on statistics was self-selecting because it only looks at referrals to them in cases of dispute rather than the non-referrals. So once you self-select your pool, your percentages inevitably may go up artificially. And that is one problem with it. And the other problem, of course, is the Court of Appeal was still criticising this policy in its updated form, even though the statistical evidence doesn't relate to it at all, because the latest form of the age assessment guidance was produced post the upper tribunal decision, and none of the statistical evidence pertains to that at all. My lords, I ought to finish because the others need to speak, but so far as the interveners' submissions are concerned, we adopt the upper tribunal's analysis of them. They're in essentially the same form as they were before the upper tribunal. Upper tribunal paragraph 78 to 82, electronic bundle 258. Nothing in the Strasbourg jurisprudence adds to the picture. Indeed, it appears, as your lordship will see, from Majorca and Belgium, and indeed Jammer and Malta, simply to establish that even detention of children is permissible under Article 5.1f, subject to limits. Whereas, of course, in this country, as a result of the change in law, the detention of children isn't. So, in fact, the common law position and legislative position here is stronger than that in Strasbourg. The Strasbourg jurisprudence adds nothing. And the other submissions made about the general comments of the CRC, which we made, don't actually assist at all, because they are simply identifying what is required when age assessments are taking place in cases of doubt, which is, of course, the age assessment process for Merton B compliance. It doesn't dispute the principle that you don't need to do age assessments where there isn't doubt, which is what criterion C is directed at. And it doesn't address the procedural safeguards, the benefit of the doubt that's implicit before criterion C actually applies at all. And therefore it adds nothing to the picture. My lords, in those circumstances, I better stop, but we would ask the court to allow our appeal, unless I can assist you further at this stage. Those are our principal submissions, along with our written case on the appeal.
Thank you very much, Mr. Strawn. Mr. Homer, I'm grateful to you for your patience. I'm afraid we lost time with Mr. Strawn through technical interruptions. But we're now looking forward to hearing your submissions.
Thank you, my lord. I hope you can all hear me clearly. And I hope it's helpful if I start with a summary of our position. This is not a case based on a submission that the policy is unlawful because it produces a risk of unfair outcomes. Rather, it's because the policy creates a risk of unlawful outcomes. The challenge on this basis falls comfortably within the public law orthodoxy and has done so since at least Gillick. It engages the grounds of ultra vires and rationality. Now, the Court of Appeal didn't review all the cases from Gillick onwards because they didn't need to. It was never suggested that a challenge to a policy on the grounds that it produced results that were unlawful, indeed contrary to the statutory prohibition it sought to give effect to, fell outside the scope of judicial review. Rather, the debate, at least prior to the commencement of the hearing before the Court of Appeal, focused on two questions. Firstly, what were the criterion to be applied when determining whether a policy fell foul of public law grounds? Secondly, how should that test be applied in this particular case? Now, in respect to the first question, the parties effectively agreed at the hearing before the Court of Appeal as to what the test should be. And there was agreement that the test should be whether the policy gave rise to a real risk of unlawful outcomes in a legally significant number of cases. And this was the test that the court applied. Can I just show, my lords, what the position was? And we can pick that up in the judgment of the Court of Appeal, electronic 193. Paragraph 60, my lords can see that the Vice President said there was initially an apparent dispute before us as to the criterion to be applied in deciding whether a policy of the kind of which we are concerned is unlawful. And his lordship there sets out the case that we advanced and the intervener advanced. And then if we turn to paragraph 62, the Vice President says this: in his skeleton, counsel did not accept the two supreme authorities relied upon by counsel for the appellant and intervener were directly applicable because they were concerned with legislation rather than here with guidance. He contended the principles would be found in Lord Justice Law's judgment in the Director of Legal Casework. However, the point need not be pursued because in his oral submissions he acknowledged that there was no substantive difference in the various approaches, save for the one that you see. And it's in light of that concession that we move to the test at paragraph 63, where his lordship says, I don't think it's necessarily useful to analyse the various cases referred to. In my view, the correct approach in the circumstances is straightforwardly that the policy contained in the EIG and the relevant parts of the setting age will be unlawful, but only if the way that they are framed creates a real risk of more than a minimal number of people being detained, i.e. of an unlawful outcome. My Lord Sales.
I have some difficulty with that, because might it not be said that that's a risk that is inherent in the statutory test? So the statute creates, or the various statutes create, a dividing line of 18. And it's just inherent in the difficulties of telling whether an individual, in some cases, is or isn't 18 or over 18, that the statutory test will lead to some cases being incorrectly categorized, because no test could be absolutely perfect.
My lords, of course, and I'm going to come to that if I may, because I'm going to, after the lunch break, develop my submissions on all the points at the moment I'm merely summarising, and I am going to address that point head on, not least having set out what we would say is the relevant statutory context and what the policy means when properly construed. Would my lord forgive me if I come back to that in the context, which I really am going to address it head on. At the moment, I've just...
Can I ask you, are you also going to come back to unison?
I am, my lord, yes.
Okay, I'll be patient then.
I'm going to touch on it in my summary now, and then I'm going to come to it in a little detail later on. So we can see that the test was applied by agreement between the parties, and I'm going to develop submissions as to why it's the correct test in the circumstances. As to the second question that was before the Court of Appeal, which is how does it apply on the facts of this case? Can I start just by summarising on a general level how one approaches that question? when it's a policy that's sought to be impugned. The identification under the test of what a real risk means and what a more than minimal number of cases mean will depend upon the facts of each case and the nature of the challenge that is being brought. The answers lie in the assessment of a range of factors, including the relevant statutory context, the potency or directness of the link between the policy and the unlawful outcome complained of, the likelihood of illegality eventuating, and the nature of the unlawful outcome itself, not least whether it concerns fundamental rights. Now, there will be some cases which require proven examples of unlawful outcomes actually having resulted from the policy to demonstrate that that test is met. Others will not. At one end of the scale are cases such as Unison, and we would submit this one, where the link between the impugned policy and the plainly unlawful outcome is sufficient that a real risk can be demonstrated without the need for repeated proven examples. At the other end of the scale are cases such as the Director of Legal Case work, where the court has to distinguish, often on an impressionistic basis, as my Lord Briggs put it in that case, between a system which, although blighted by multiple instances of unfairness, is inherently fair, and a system that is rendered unlawful by inherent unfairness. And in those types of cases, considerable evidence may be required to reach the right answer. Now, we submit that the Court of Appeal's approach to these tests and its application to the facts of the case before it was unimpeachable. It identified the relevant statutory context in which prohibited the detention of children. It identified, on the basis of long-established expert analysis, that visual assessments of age carried with them a recognised margin of error, and it identified why the policy gave rise to a real risk of unlawful outcomes, because it failed to account for that very margin of error. And in the context of the statutory prohibition on child detention in the immigration system, it was entirely right, we submit, to conclude that a real risk of falsely imprisoning more than a minimal number of children was legally existed and would be legally significant. And we submit that these were conclusions that the Court of Appeal was fully entitled to reach without regard to any evidence of actual unlawful outcomes having occurred. But the fact is that the correctness of their conclusion were corroborated by the very considerable amount of evidence for them, not just the data, but of the witnesses. My Lord Sales, I think, has a question.
Yes. Would you accept that there would be unlawfulness involved under one or more of the statutory regimes to treat an adult as a child and, for instance, place them with children, give them access to the benefits which are intended under the statutory regime to be focused on children?
No, my Lord, I won't. And one of the things I was going to deal with was a point arising out of a question of Lord Reid in respect of the is there a tension here with the requirements under the 2002 Act? And I was going to deal with that and incorporate the points from my Lord arising out of my Lord Sales questions as well.
I'll wait. Thank you.
The Court of Appeal looked at two sets of policies, as you've seen. We submit that all three members of the court were correct in concluding that those in place at the time of the upper tribunal gave rise to a real risk of unlawful outcomes to more than a minimal number of children. And we submit that the conclusions of the majority in respect to the updated policy are equally unimpeachable because they rightly identified that although an improvement, the amended policies did not address the root cause of the illegality. Now, my Lords, can I frame my submissions under both grounds 1 and 2 by highlighting what we say are 7 uncontestable factual features of the case? Firstly, the unchallenged evidence before the court, drawn from a succession of cases and from evidence of relevant experts, is that assessing a person's age by reference to their appearance and demeanour is a notoriously unreliable methodology even when conducted by trained social workers. You've seen that from Merton. Second, a well-recognised reason why it is such an unreliable methodology is that even paediatricians and other child health experts are warned by their Royal College that a 17-year-old can be mistaken as looking as though they are 23. In other words, the appearance and demeanour of certain children might strike even highly trained healthcare professionals as strongly suggesting they look significantly older than 18. Put it at its most neutral, there is no reason to consider that immigration officers, whom it is accepted receive no relevant training in age assessment, would be able to more accurately apply the margin of error. Third, there is nothing in any of the relevant policy documents that directs the decision maker to the fact of the margin of error insofar as it relates to the task that they are undertaking in age assessment. Nor is there anything in the policy that explains what significantly means in the context of the margin of error. Nor does it make plain that if applied to those who look between, say, 20 and 23, it could result in wrongly assessing a child to be an adult. Indeed, the age assessment guidance in the form before the Court of Appeal, but not the upper tribunal, expressly eschews any utility in providing the decision maker with assistance on what significantly over 18 means. Could I just ask you to turn to page 777 in assessing age in the version before the Court of Appeal? And you will see in the middle of the page, the age a person must exceed to be regarded as significantly over 18 is not specified within this guidance document. It's consistent with the upper tribunal decision in this case. And then the citation from the upper tribunal, since the objective of the policy is to identify by way of initial screening assessment cases that are outside the category of borderline cases, it's not apparent there'll be any value in greater precision such that an assessment can deliver. And for your note, you may wish to cross-refer to the Vice President's treatment of the upper tribunal's comments, which you'll find at paragraph 66, page 195. And could I just deal here with the reference to the paediatrician's report that my Lord Briggs drew attention to this morning? A few things to say about this. Firstly, it does not fall within the section that is dealing with the appearance and demeanour test. This is dealing with how officers in a different context should treat a paediatrician's report. Secondly, when one reads it, it is clear that it is saying the margin of error here is relevant because just because a paediatrician tells you somebody is 17 doesn't mean that you need to rely on that. It's flipping the margin of error on its head. And thirdly, because one needs to construe the policy as a whole, it's highly germane to take into account the fact that until my Lord Briggs raised this document this morning, it's never been suggested by the Secretary of State that this is something that falls to be construed as part of the exercise that the officer is undertaking, rather than just something that deals with a different aspect. So it's never been part of the Secretary of State's case that, in fact, the margin of error is part of the test and is the mind of the officer is directed to it. And I'll just show you the passage that suggests the contrary. Fourthly, it's perhaps unsurprising in light of this evidence that there's no dispute that the impugn policy has led to children being wrongly classified as adults and therefore liable to detention. This is recorded in terms in paragraph 69 of the Court of Appeal judgment, where the Vice President stated that the fact that numerous assessments by immigration officers, stated that the fact that numerous assessments by immigration officers had resulted in children being identified by adults in numerous assessments. That's paragraph 69. For this court, at paragraph 16 of its printed case, EF 65, the Secretary of State accepts that she doesn't submit that the policy ensures that children are never detained. And that is a realistic concession in light of all the evidence and the evident flaws in the methodology. And importantly, it's not suggested that these outcomes are the results of an officer misunderstanding the test. These are not examples of a misunderstanding, let alone a bad faith application. These are examples of what happens when the policy is applied on its face. My Lord Lord Sales. I'm so sorry, my Lord.
Yes, sorry, I was muted. It's the same problems I had before, that the statutory regime imposes the cutoff of 18. And we know there are difficulties in precisely applying that with accuracy in every single case.
Yes.
So the policy doesn't create the problem. Your case seems to be that somehow the policy has to correct what, as I'm understanding, in effect, you're saying is a defect in the statutory regime.
No, my Lord, because I mean, I'll come to it in a little more detail after lunch. But we don't say, I mean, it's not the logic of our argument that there could never be a policy that would be lawful. There can certainly be policies that do not produce a legally significant number of children being detained.
If you had a policy that said only treat someone as an adult if you believe they're 40, that would probably go quite a long way to eliminating the risk. But that would be very far from what Parliament has said the relevant test is.
Of course. In fact, we have a good example of what a policy might look like that doesn't produce a legally significant number of children being unlawfully detained, and that's the current policy that's been put in place since the Court of Appeal, which removes the words.
Forgive me for interrupting, but that says treat someone, don't treat them as though they're a child unless you believe they're 25.
Yes.
So it's the same point, that the underlying statutory test is the dividing line is 18. But you're saying you need a policy that says only treat them as 18 if you believe they're 25.
No, my Lord.
It's a bit odd.
No, my Lord, because our submission, consistent with the core analysis of the Court of Appeal, is that any policy has to take into account and has to direct the decision maker's mind to what is established margin of error. And that margin of error isn't plus or minus 10 or 12 years, it's plus or minus 5 years.
Right. I'm conscious we've got to stop. We're about to stop. Can I just ask you, do you say that there has to be a policy, or could the Secretary of State simply have had no policy?
No, there has to be a policy, and I'm going to take you to lumber, and I'm also going to suggest this is a policy that is a statutory requirement under Section 55. It doesn't really matter, because any policy would be, whatever the route would be required, it would be amenable to judicial review on the same grounds in any event, we would say.
Yes, thank you.
My Lord, I've gone over 1 o'clock.
Well, you were taken beyond 1 o'clock, I think, by the enthusiasm of my colleagues. Would this be a convenient point for you to break? Well,
yes,
we'll adjourn now and resume at 2 o'clock.
Thank you very much.